You're watching Center Stage with Rahul Kanwar.
Good evening. In a case based entirely on circumstantial evidence, the CBI argued hard for the death sentence against the Talwars, which is granted only in the rarest of rare cases. The Talwars are crying injustice. They say this reflects the rarest of rare biases on the part of the CBI, and that's our top focus on the show tonight.
Rajesh Talwar, Aarushi's father and the man convicted of killing her, is now prisoner number 9342, lodged in ward number 11 of Dasna jail. Nupur Talwar, Aarushi's mother and Rajesh's partner in crime, is now prisoner number 9343, lodged in ward number 13. This brings to an end the trial of India's biggest murder mystery. But this brings no closure. This doesn't answer all the questions that will now linger for years to come.
The courts, the CBI, the people who followed the double murder, owe the 14-year-old Aarushi and Hemraj just one thing. We owe them the commitment to bring out the truth. The verdict is out, but the arguments over what happened that night continue. The Talwars have been convicted, jailed for life, but nagging questions remain about whether they've been done in by a shoddy probe. On the show tonight, we will argue and debate whether the CBI's bias in the court today came out into stark light. In a case where thin and circumstantial evidence, CBI lawyers argued for the maximum punishment. Is this reflective of the rarest of rare biases? Let's get started. These are the stories that have taken center stage tonight. Public slander follows private apology. Tehelka founder Tarun Tejpal now discredits the victim, questions why she was partying after her claim of being molested. Will Tehelka go bust? Magazine's chief investor says he's pulling out of the venture, insists Tarun was a personal friend, but this is not the Tarun he knew.
The person Tarun I know, and I think the right way would be to submit to the law of the land and face the consequences, if any.
Tarun Tejpal's bail plea to come up for hearing tomorrow. Goa police sound alert prohibit him from leaving the country. Will he be arrested in the next 48 hours? Narendra Modi finally responds to the outcry over Snoopgate, orders a probe into charges that his government abused its powers. The Congress calls the panel an eyewash. Bangalore's shamed a 16-year-old girl allegedly gang raped by 5 people near the old airport area. 4 youth are arrested, police on the lookout for the 5th. This was supposed to be the moment of closure, but it sure doesn't look like it. At 4:30 this afternoon, the CBI judge sent Nupur and Rajesh Talwar to jail for life. The verdict came 5 years after the murder of Aarushi, Talwar and Hemraj. Here's how the final blow to the accused parents in India's biggest murder mystery was delivered.
This was meant to be it. This was meant to be the closure. The fate of the Talwars has been sealed, but this debate continues. It went on in the CBI trial court between the defense and the prosecution for one last time for 15 minutes. The CBI demanded maximum punishment, saying the murders committed were gruesome. The defense pressed on the point the case was all based on circumstantial evidence.
At 4:30 p.m., the judge entered the court and sent the Talwars to jail for life. The Talwars this time didn't break down, but tears welled in their eyes as they were led out once again for Dasna jail.
सेक्शन 302 आईपीसी में लाइफ इम्प्रिजमेंट, आजीवन कारावास, उम्र कैद की सजा सुनाई गई है दोनों को, और सेक्शन 201 आईपीसी में 5 ईयर 5 साल की सजा सुनाई गई है दोनों को।
कोर्ट में हमारे आर्गुमेंट यही थे कि मर्डर जिन हालात में किए गए हैं उस हिसाब से इनको मैक्सिमम पनिशमेंट मिलनी चाहिए। उसके बाद कोर्ट को जो मुनासिब लगा कोर्ट ने जजमेंट अपनी सेंटेंस पे पास कर दी।
I definitely believe that the judgment of conviction which was passed against them is unsustainable in law, it's unsustainable on facts, and that we have a very, very good case in appeal. We have to file the appeal. We will do so.
As he delivered the final blow, the judge seemed to be softening it. Convicts, he said, are not a menace to the society, and that sentence is not required. End of justice will be met if they are awarded life imprisonment. Within minutes, Talwars were taken again to the Dasna jail.
Dr. Rajesh and Nupur Talwar entered this gate of Dasna jail at 4:48 p.m. on Tuesday. The Talwar couple have stood by each other for the last 5.5 years, but here in Dasna jail they will be lodged at a distance of half a kilometer, with Dr. Rajesh Talwar lodged in the male barracks and Dr. Nupur Talwar lodged in the female barracks. They will only be allowed to meet once a week on Saturdays for 20 minutes.
That is true. This time their behavior is different. Their shocking level is different. Their depression is different. And I think their behavior and cooperation with the jail administration is different. They are not, earlier they were cooperating with the jail authorities. This time they are not cooperating.
From today, Rajesh Talwar will be prisoner number 9342, lodged in ward number 11, and Nupur Talwar, prisoner number 9343, lodged in ward number 13 of Dasna jail. But the fight will now move to higher courts. The Talwars will move to challenge the verdict and then seek bail. This as they vow to fight on till justice as they see will be delivered in the case. In Ghaziabad with camera person Hemant, Aditi Anant Narayanan, Vijay Kao and Padmada Joshi, Ankit Tyagi for Headlines Today.
Last evening on Center Stage, we looked at the arguments that were being made by the Talwars in their defense, the gaping loopholes that still remain unanswered. Tonight, at the beginning of the show, we will look at the arguments that have been laid out by the judge in convicting Nupur and Rajesh Talwar. I want to introduce to you Tanveer Ahmed Mir. He's the lead counsel for the convicted Talwar couple. With us also in the studio is Masuma. She's a mother of Aarushi's friend, very close family friend of the Talwars. Arima Sundaram, one of India's best known lawyers, is also joining us on this broadcast. But I want to get started first with Tanveer Ahmed Mir. And I want to take you through what the judge has said in this verdict. And I want you to answer the points one by one. Because the first point that the judge makes, which is very important, is that Aarushi's bedroom had an automatic click-shut lock, like that of a hotel, which could not be opened from outside without a key, but could be opened from inside without the key. No explanation has been offered by the accused as to how the lock of Aarushi's room was opened and by whom. The allegation being that it is only the parents who had the key. They're the ones who opened Aarushi's bedroom. They're the ones who went in and murdered her.
See, on this aspect, the learned trial judge respectfully has completely missed the complete explanation given in the statement under 313 by both Nupur Talwar and Rajesh Talwar, which admission or a statement was given in the protest petition even before the trial began as a matter of admitted position. Can you keep the
legalities out, explain in language that people understand what the defense is?
In very simple language.
This is not a code of law. People have followed this case. They want you to answer the question that I'm asking.
Let me tell you, in very simple language, a statement had been made that the key of the room of the lock remained in the lock itself. Therefore, any person could have opened because it was an automatic
lock. No, but it
lock.
also says in the verdict that Nupur Talwar says that the key was lying under her pillow while she slept at night and nobody else had access to that key.
No, that is one part of the statement. The other part of the statement is that when the internet router was switched on at 11 o'clock, even before the trial began, it was very candidly stated by both Nupur and Rajesh that the key of that lock remained in that lock. Now, when the earlier set of accused persons were arrested, the theory at that time was that the door was not locked, it was half open. That's how the entry was gained. To that extent, the honorable judge has been selective.
No, but it also says, and this is a very important point as well, that the clothes of both the accused were not found soaked with blood. It is highly unnatural that the parents of the deceased Aarushi did not cling to her, did not hug her when they saw her murdered. Now, this is a question the Talwars haven't been able to argue and explain.
This finding is completely fallacious and is belied by the DNA analysis of the clothes of both the parents, which found blood of Aarushi alone and no other blood.
No, but the judge says that no blood of Aarushi was found on the parents' clothes. That's the evidence that he's citing in his conviction.
That's why what I'm saying is that this piece of finding is completely erroneous and is completely contradictory to the forensic evidence which is established on record, the report of Dr. Mahapatra, prosecution witness number 6, who had examined clothes of Nupur Talwar and Rajesh Talwar which they were wearing in the night. The clothes of both the accused was bearing blood of Aarushi alone.
Okay, it also says that Bharti Mandal, who's the maid, reached the flat of the Talwars, talked to Dr. Nupur Talwar. At that time, she did not complain about the murder of her daughter. Rather, she told the maid that Hemraj has gone to fetch milk from the mother dairy after locking the wooden door from outside. The judge says the lack of spontaneity is relevant under Section 8 of the Evidence Act.
Look, the time when Bharti Mandal came at 6 o'clock in the morning, the wooden door was not locked from outside. The wooden door also had an automatic lock. It could be opened from inside by just moving the handle. Now, the judge has accepted in his judgment that Bharti Mandal, being a maid servant, has been tutored by CBI. Now, this is a very, very strong finding.
You don't have any evidence to back that.
No, the question is here, what you must appreciate, that in a court of law, if a witness is tutored by an investigating agency just before her testimony is to be given in a court of law, she's not rendered creditworthy by any stretch of imagination.
You don't have any evidence to back that, counsel?
No, this is a finding in the judgment. I can show you in the finding. Kindly see page 91 of the judgment, and at page 91, there is a crystal clear finding by the Honorable Trial Court that Bharti Mandal has been tutored, but despite that finding, he goes on to believe a tutored witness. Now, you can ask this question to Mr. Sundaram, the learned senior advocate, that in how many judgments has he seen that the moment Supreme Court gains knowledge that a witness who has been tutored has been believed, whether that witness is rendered creditworthy and reliable in a criminal trial.
Okay, it says it is not possible after the commission of the crime that an outsider will dress up the crime scene.
Look,
that Aarushi's private parts had been cleared, that she was lying on a bed, properly dressed up. That's the way the body was found. This is
a very unfortunate finding based on an unfortunate allegation. What is very important here is that when is this allegation coming and who makes this allegation? Now, the question here is that this allegation is made by Dr. Sunil Dore as much as in his 6th statement after about 2 years from the murders which were committed in the night between 15 and 16, and the improvement was so material that from his post-mortem report, where after conducting examination of private parts, Dr. Dore wrote 3 words NAD, no abnormality detected. His final 6th statement made to the new investigation team and his court testimony was diametrically opposite to his own post-mortem documents and earlier statements. When any witness makes such material improvements going to the root of his testimony, no court of law can accept his testimony.
But the reality, Mr. Mir, is all these points you can cite tonight,
yes,
the court heard all these arguments and came to the conclusion that you don't have a strong case. I want to argue further the next point.
Yes.
That it is not possible that an outsider, after committing the murders, will muster the courage to take Scotch whiskey, knowing that the parents of the deceased Aarushi are in the nearby room. His top priority will be to run away from the crime scene immediately.
Look here, the earlier CBI theory. Now, this entire case is a baby of CBI. Nothing has been introduced by me as a defense counsel. Now, there was not only a Ballantine Scotch bottle, there was a full Sula wine bottle, a beer bottle, and a 2-liter soft drink bottle which had been consumed. All 4 bottles were having blood. And the Ballantine's bottle was on the dining table. 3 other bottles along with 3 glasses were in Hemraj's servant's room. The learned judge finally has returned one of the findings which bewilders me when he says that Dr. Rajesh Talwar allegedly, after committing the double murder, consumed the entire Ballantine Scotch, consumed the entire Sula wine.
He only talked of the Scotch, he doesn't talk of the others.
No, when you will read the judgment further, you will get it. The entire beer bottle and 2 liters of soft drink bottle, because on that aspect, the CBI case was very weak. So ultimately, I'm bearing consequences of somebody else having consumed alcohol in my house and having committed this double
No,
murder.
but it also says that the pattern of the head and the neck injuries of both the accused persons are similar in nature and were caused by the golf club and the scalpel respectively. So it isn't as if they've been murdered by different people, they've been murdered by the same person.
You see, as far as introduction of golf club as a weapon is concerned, that is after a year and a half from the murders were concerned.
But that's because the golf clubs were missing before that.
No,
That's nobody.
That is nobody's case. The golf clubs were with the Talwars right from the day one. The golf set and the golf bag was never asked for. For the first time, the investigating authorities served a notice on 29th October 2009 asking Talwars to produce the golf clubs. Immediately next morning, the golf clubs were produced. Now, none of the earlier CBI investigating officers who testified in the court, for example, Mr. Vijay Kumar, Mr. M.S. Fartyal or Mr. Hari Singh, ever testified in the court that golf club was ever an issue from 1st June 2008 going up to 29th October 2009. Now, if you have two sets of golf clubs in your house, Rahul, and nobody asks for it, then you're not going to take a golf club and go to a CBI office. Look, I have a golf club set. Please also examine.
We've heard you. I want to bring in Aryaman Sundram, one of India's top lawyers, as an independent perspective on this case. The manner in which, Mr. Sundram, the CBI argued for the death sentence this morning. This is a case that's based on circumstantial evidence. There is no direct clinching evidence to demonstrate that Rajesh Talwar murdered Nupur, murdered his daughter and the servant. Do you think it reflects, as the family suggests, the bias of the investigating agency, that they were determined, regardless of how strong their case was, that the Talwars must hang? Mr. Aryaman Sundram.
Actually, I'm completely shocked. I'm shocked by the CBI having asked for a death sentence, but strangely another part of me is not surprised, because I, like many Indians, have no faith in the CBI. It's meant to be an independent, impartial, fair, investigative body whose duty it is to place the evidence before court, to do an investigation in an unbiased manner, and place the results of the investigation, the evidence, before the court. That is the duty of the CBI, in which case the CBI will be respected very much like the FBI is respected in the United States. Unfortunately, the CBI tries very, very, very hard to convince this country that they are not a body to be trusted, believed, or for people to have faith in. Today is a shocker for me. Here is a case of this unbiased, impartial, fair body insisting for a death sentence, which I presume they know the law, and I presume definitely that the CBI lawyer knows the law, is given in the rarest of rare cases. In cases like this, when a death sentence is asked for, it makes people like me stand up and say, I think it's about time we get rid of this death sentence in this country. This death sentence is just such an arbitrary sentence which is both asked for by the investigating bodies and is often finally the sentence is passed. The fact of the matter, let's just take three facts. Pure circumstantial evidence. Unless the chain is so unbroken that it leads to an inescapable conclusion that the crime has been committed and the person is guilty, the death sentence, the person would not be sentenced in the first place. Now here you have them asking for a death sentence on this. The second issue is that circumstantial evidence must be such that no hypothesis other than the hypothesis that this person has committed the murder is possible. If such a hypothesis is possible, a person is not even convicted. The third circumstance is that the guilt must be irrefutable, and benefit of doubt and the probability should be far more than a probability required in a case where it's not purely circumstantial evidence.
I must quote over here, Aryaman Sundram, from the judgment. The judge says, a man may lie, but circumstances do not. Both the accused have admitted in their written statements that Nupur Talwar removed the key from Aarushi's lock and kept the same with her. It is an admitted fact, argues the judge, that the door of Aarushi's bedroom was having a click-shut automatic lock, and as such it could have been opened either by the parents with the key from outside or by Aarushi from inside. The driver has deposed that when he talked to Rajesh Talwar, he told them that the preceding night at about 11:30, the room of Aarushi's door was locked from outside. After taking the key, he had gone to sleep. It is not the case of the accused that on the fateful night, the key of the bedroom was with Hemraj, or that they had opened the door with the key, and therefore it becomes clear that the room was opened either by Aarushi herself or by the parents. It was not possible for anyone else from the outside to unlock the door without the key. Man can lie, but circumstances never will. Aarushi Sundram.
Like I prefaced what I'm saying, I'm not commenting on the finding of guilt. I have my own view that any theory of jurisprudence, like men may lie but circumstances do not, is also tempered by a lot of other jurisprudence, which says that in cases of circumstantial evidence, and I quote from judgments of the Supreme Court, that it must be irrefutable, the guilt must be irrefutable. It must also be that no second hypothesis is possible. Absolutely. Leave that be. I'm not commenting on the correctness or otherwise of the judgment. I have not read the judgment in entirety, and I'm in no position to comment on it. I am on the issue that when there is, number one, a sentencing purely, a conviction purely on circumstantial evidence. Number two, the CBI itself at a certain stage gave a closure report saying that there was not enough evidence. Number three, the CBI's own hypothesis that this was caused because the parents saw the girl in a situation which was so angering, which was so offensive to them, that they committed the crime. I ask myself, does this make them such a menace to society? Does this make it that rarest of rare case? On the other hand, wouldn't even it be a case where someone would turn around and say, yes, they should not have reacted like that, but the fact is that there was a cause for their reaction, which was that extreme anger or offense or whatever else it was, in which case it certainly was not the rarest of rare cases to ask for a death sentence. And certainly the judge was completely right in not giving the death sentence. What shocks me is the CBI is almost acting like a body who wants to win the case. I must win it at any cost, and I must win the maximum I can win. That is not the job of the CBI. That is not the job of a fair, impartial, unbiased body. I believe it's the duty of the CBI. It's the duty of the CBI counsel himself to look into it and to see, look, would this be one of those rarest of rare cases where a country which is one of the few countries in the world which still has a death sentence would still give a death sentence? Is it one of those rarest of rare cases? I wonder whether they have even applied their mind to deciding whether they should ask for a death sentence in a case like this. And I would have hoped a body like the CBI and the counsel for CBI would have looked at it and said, look, they are guilty, they should be sentenced, but maybe this is not what the Supreme Court has called rarest of rare cases.
You made a very compelling argument, Mr. Aarushi Sundram, and I want to introduce to our program at this time former CBI Director Joginder Singh, because you've leveled some very serious charges and you're raising some very pertinent questions about the conduct of the CBI. You're saying the CBI doesn't seem to have applied its mind, it seems to have taken a preconceived position on the guilt, and it seems to be out to prove that this is a match that they're out to win. Joginder Singh, what do you as the former director of this institute have to say about the behavior of the CBI lawyers in court today? Aarushi Sundram says they went in with a preconceived notion that this is an argument they have to win. They seem determined to hang Talwars regardless of whether there was evidence to back that or not.
No, this is, I would only remind you, Rahul, the legal position is the CBI had submitted a closure report that they feel that he's guilty, but there's not enough evidence to...
Mr. Joginder Singh, I don't want you to digress. I'd like you to answer my question. I'm asking you a direct, straight question on the behavior of the CBI counsel in the court today. Do you condone what the CBI counsel did, or will you say what the CBI did today in court was completely unacceptable? Answer just this one question without going into a long-winded response, Mr. Joginder Singh.
I'm answering your question. I'm saying here the CBI, when it appears for the prosecution it is duty bound to ask for the maximum punishment. It is a magistrate a judge who never appears. If he says the case should go on, trial should go on. Should they have gone back to the magistrate? We don't carry out your orders. See, this is for these people to challenge it.
I'm on the
This is a
asking of the
normal
death
Aryaman
tradition.
Sundaram wants to come in because KTS Tulsi is also
Yes.
joining us in this program, and yesterday he was arguing that on the basis of the evidence available, the Talwars are guilty. But let Aryaman Sundaram make his point before I bring Mr. Tulsi. And yes, Mr. Sundaram.
No, my point is very simple. They have been found guilty. There will be challenges, I'm sure, that will be decided. I'm not commenting on that. But I'm asking whether this was a case where the prosecution, and let's not forget that traditionally the prosecutor's role is to impartially place the evidence for the court to consider. Is this a case where the CBI and the CBI counsel, the prosecution, should insist on a death sentence? Or should they themselves have thought twice about the Supreme Court rules about when death sentences are given?
Mr. Joginder Singh must respond.
No, true. But it's up to the... I'm answering to that. It is up to the next higher court to set it aside. Traditionally, normally, the maximum punishment is demanded, and there's nothing illegal about it.
I'm not
there
on
is nothing
conviction,
illegal
sir.
about it.
I'm on the request for
No, it's not about legality. Mr. Joginder Singh, it is about whether the CBI counsels themselves believe that this is the rarest of rare cases. I want to bring KTS Tulsi in because yesterday he was arguing very vehemently that the Talwars on the basis of the evidence that's available were guilty. The family was arguing that the Talwars are, that the CBI is acting in a preconceived fashion. Mr. KTS Tulsi, you've heard Aryaman Sundaram. He says the CBI did not apply its mind. They seem to be acting as a party in this case. They were determined not as independent investigators, but as people out to prove that the Talwars were guilty and therefore needed to hang. Mr. KTS Tulsi, respond to Aryaman Sundaram.
This is what the magistrate decided.
Yeah, I agree entirely with Mr. Sundaram, and I feel that it is completely wrong for the prosecutor to adopt a stand that we want a highest punishment in every murder case. Then where is the theory of rarest of the rare? The prosecutor has to give enlightened advice to the court, and you must realize that this is something tragic. Mr. Joginder, can I have my say?
No.
Mr. Joginder Singh, let KTS Tulsi complete. I'll give you the opportunity to rebut.
Can I speak?
Yes. Okay.
I feel that it is absurd on the part of the prosecutor to, in a case like this, in which the death may actually have been accidental. It's a different matter that right from the beginning they try to dress up the scene, they try to obfuscate the issue, but it is not that it was an intentional murder of particularly their daughter. So there were circumstances which may have resulted in this situation, but nevertheless, I don't think this is a case which called for death sentence. The learned prosecutor ought to understand his responsibility.
Okay, Mr. Tulsi now criticizing the attitude of the CBI lawyers. But does this not, and I want to bring in Vandana Talwar, the sister-in-law of Rajesh Talwar, because the family has been arguing that the CBI is acting in a malafide manner against them, that they've made up their mind that the family is guilty and are doing what it can to ensure that the family is hanged without looking at all counter evidence. You've heard from Aryaman Sundaram. It seems that the attitude and the behavior of the lawyer in the court today seems to bear testimony to what you've been saying, Vandana Talwar.
Yeah, Rahul, that's what I want to say. There's lots of evidence which the CBI has decided not to put in the court. Among that, the most important was the scientific test and the sound simulation test. The sound simulation test was done by the Joint Director CBI of the first team, in which they had done the test between 12 and 1 midnight in June 2008, and it was found that when ACs of both the rooms were switched on and Aarushi's door and Rajesh and Nupur's doors were closed. So what they found was that loud noises made in Aarushi's room did not reach Rajesh and Nupur's room. So there is a possibility that there were maybe some outsiders in Aarushi's room and Rajesh and Nupur did not hear about it. But that test, which was done by the CBI only, it has not been put with the reports along with the closure report.
Mr. Joginder Singh, you must answer.
My question is that why
the
have
CBI's
all
actions.
Rahul, please let me finish. There are a couple of points which I need to make. Please let me finish.
Just let Vandana Talwar complete.
My question is that why have all the points, why have all the tests which were done by the CBI, why were they not put on record? So were they trying to hide something? One was this, and the scientific test of Krishna, Rajkumar and Vijay Mandal, lie detector, brain mapping and narco-analysis was done. All showed their guilt in the crime. And
That's
all
not even
these
admissible.
scientific tests done on Rajesh and Nupur Talwar, please let me have my say. They showed they were innocent. The CBI can get a lead from this, from the scientific test. They may not be conclusive, but definitely they can get a lead on it. Now, why were these tests not put before the court? Is it the decision of the CBI to decide whether these tests are the ultimate or not, or is it the decision by the court? All I am trying to say is that CBI had done these tests. We had not done these tests on our own. So when they had done these tests, why were they not put in court? They are still not there in court. The sound simulation test, we later went to the High Court, and it was the High Court gave a decision for it to be put on record. So now that has come on record. But the scientific tests are still not on record.
Mr. Jogender Singh, explain the actions of the CBI. How can they act in a completely one-sided fashion?
Absolutely.
Consider both sides of the evidence and let the judge decide. Isn't that what the CBI should be doing, Jogender Singh?
You see, hold on. After them, I'll let them make the point, then I'll answer that.
I would like to make
Now,
Vandana Talwar, you've said enough. Let Jogender Singh respond. I'll give you an opportunity to make a further argument. Jogender Singh must respond to what you've said.
Please do that. Please do that.
No. You see, there are certain tests which are recognized by the courts. That is by the Central Forensic Science Laboratory tests and some tests. And you will be surprised in this case itself. The two centers differed on the assessment of various things here. So what do they put? If they put up, they'll be only confusing the court. Because they didn't trust those tests themselves also. And this nice test and other tests, they are not recognized anywhere in the court. Hold on. Let me have my say. No, you can't. I didn't interrupt you. You just listen to me on this. See, please remember that it is the court which ordered the prosecution. CBI itself said that it doesn't have enough of evidence. But the court in its wisdom decided that let the trial go on, and this entire thing was converted into a charge sheet here. So you have to give some credit that also here.
But Mr. Jogender Singh, there has to be some logic to the CBI argument. First, the CBI argues that there isn't enough evidence to lodge a case against them, to charge sheet them. Then you argue that there's enough evidence to hang them. Mr. Ariman Sundram wants to respond to what you are saying because the argument has to be sustainable. Mr. Ariman Sundram.
I find this completely self-contradictory. On the one hand, you're saying CBI was being fair enough to say there was no evidence to go ahead with the matter. At the same time, you're saying CBI was right in insisting for a death sentence.
They can't say,
are you taking it? Mr. Singh, I have a question for you.
I have a question for you. Mr. Jogender Singh, you are rambling on. Just listen to Ariman Sundram and respond to his question. Mr. Jogender Singh, allow me to mediate. Let me play the role of moderator. Do not speak simultaneously. Mr. Jogender Singh, just allow Ariman Sundram to frame his question. Then you will get the opportunity to answer. Mr. Ariman Sundram, please go ahead. Jogender Singh, listen to him.
I have one question for Mr. Singh. Does he feel that the moment a person is convicted of murder, it is the duty of the CBI to then ask for the death sentence, and that's the duty of the CBI, and it's for the court to decide whether to give it or not? Or does he feel it's the duty of the CBI and the lawyer and the prosecutor to themselves look into it and to see whether this is a case which is the rarest of rare cases? Or does he feel that in every case of murder, it's the duty to ask for the death sentence?
Mr. Jogender Singh.
Shall I answer it?
Yes, please, of course. Now you must.
It is not for CBI to decide which is, it is not the duty of CBI, which is the rarest of rare court, their offense. It's for the court to decide. The same court can turn around and tell the prosecutor, who the hell are you to decide? He killed his own daughter, and then you say this is not rare as rare. I think you are expecting unfair. You want the CBI to go halfway, carry out the order of the magistrate, but say, sir, we have committed a mistake. Please give them a little less sentence here. Nowhere in the world prosecutor
on the mistake, sir.
They demand
CBI can say this is not a rarest of rare case.
Domain of the
okay. We've argued this point. We've argued this point. You've heard from both sides. You've heard Ariman Sundram. You've heard Jogender Singh. I want to move the debate in front. Just take it a little further, and I want to go across to KTS Tulsi, because I'm reading now from page 109 of this judgment, where the judge says that the motive of the crime stands proved. He says, which is what the CBI has been saying, that Aarushi and Hemraj were found in a compromising position, which is why the father got angry, and in a fit of rage, he killed Aarushi and then Hemraj with the same murder weapon, which is the scalpel and the golf club. But Mr. KTS Tulsi, the reality is that not one drop of blood of Hemraj has been found in Aarushi's bedroom. If he were murdered in that same room by the same father with the same set of weapons, would there not be a drop of blood somewhere in Aarushi's bedroom? Mr. KTS Tulsi, how do you respond to this?
I don't know whether the judgment deals with the argument of dressing up, because there was evidence that the crime scene, that is the bedroom of Aarushi, was dressed up. The pillow covers were changed, the blood stains were removed from the wall, the blood stains were removed from the floor.
One by one. One by one. Yes, Mr. Tulsi.
The bed sheet was changed. The bed sheet was changed. I don't know what the finding is, but that
the floor was
too much is being said. That is what we have.
No, but Mr. Tulsi, you're not answering my question.
Permit me.
My question, Mr. Tulsi, is that no evidence has been found, which shows the blood samples of Hemraj in Aarushi's room. No scientific evidence, no forensic evidence demonstrates that. How can you establish that Hemraj and Aarushi were found in a compromising position? I'm coming to you, Vandana Talwar, but Mr. Tulsi, who's been defending the case against the Talwars, must first answer.
Mr. Tulsi has no point to make.
Let him answer.
No, but
Well, I'm sorry I've caused so much of anguish to you and anger, but what I want to say is that if blood has not been found as a result of it having been cleaned up, then when the finding is that you have destroyed evidence under section 321 also,
Mr. Tulsi,
they have been convicted.
Mr. Tulsi, you're a very learned counsel. I must ask you just one question. Blood can be cleaned up from the pillow cover, it can be cleaned also from the bed sheet. What about the mattress? Blood soaks into a mattress almost immediately. If there was blood of Hemraj, would it not have been recovered from the mattress? Mr. Tulsi must respond. Mr. Tulsi must answer that question.
Please allow me, Rahul.
I'm coming back to you, but I want to hear from Mr. Tulsi.
You are not allowing.
If there is an allegation of destruction of evidence which has been found to be credible, which is found to be established, in that case, the accused is not going to get any benefit of the fact
Mr.
that
Tulsi, there was no allegation that the mattress was changed. Yes, Vandana Talwar must come in, because there was no allegation against the family that the mattress was changed. The mattress was the same. Absolutely. If it had blood stains, it would have had the blood stains of both Arushi and Hemraj. Vandana Talwar comes in, and Masuma has also been waiting. Yes, Vandana.
Yeah, what I want to ask Mr. Tulsi
I said the scene was destroyed. Dada police didn't collect all that.
Yes, Vandana Talwar.
Blood of Aarushi was found in the room, but blood of Hemraj was not found in the room. So are you by any chance suggesting that Rajesh and Nupur have selectively cleaned the blood of Hemraj so that has disappeared and only the DNA of blood of Aarushi is found? Then how has it happened? How can you explain it?
Mr. Jogender Singh must explain. How do you, Mr. Jogender Singh, when you are cleaning up blood? Mr. Jogender Singh, let me assume for a moment that the blood was cleaned up by the family. How do you selectively clean the blood of Hemraj but leave the blood of Aarushi? How do you do that? What medical wonder allows you to do that? Mr. Jogender Singh must answer tonight.
No, hold on. 2 weeks later on, the case was transferred when CBI took over. All the fingerprints, blood stains.
But the blood was there on day one. The UP police has taken the blood samples.
No.
On day one.
The floor was no. Let me complete. You can say anything here. No, the floor was washed off. This is some of the circumstances here. It's not that I have said it here.
I would like to step in, Rahul, because this is all wrong information.
No. It was
each other, then the viewers get confused. Vandana Talwar, can I request you with folded hands? Let Mr. Jogender Singh complete his argument, because he's not presenting a compelling argument. Let viewers also understand the weaknesses of his argument. Let Jogender Singh complete. I will come back to you, Vandana. Yes, Mr. Jogender Singh. How do you clean out Hemraj's blood but leave Arushi's blood?
No. Point is here, when you wash up the entire room, change the clothes, change everything here. What is the difficulty?
What about the mattress? What about the blood samples from the mattress?
No.
You want to come in, man?
I want to come in.
Yes.
I think Mr. Joginder Singh and Mr. Tulsi are so ill-informed about this. And I want to put this on because I went...
If you don't support them, then you are against them.
Can I speak?
We have full sympathy for Dr. Talwar.
Can I speak, sir?
No, but we're not on sympathy, we're on facts, we're on evidence. We're not on sympathy here.
Yes.
Nobody wants a sympathy.
Masuma, go on. Just 1 second, Mr. Joginder Singh, straight down, please. Masuma, go on. One by one, please.
We will not solve the problem.
Please stop speaking, let me speak.
Just 1 second, turn it straight down. Masuma, go on, quickly.
I went into that house at 9 o'clock. And I saw blood on the wall, I saw blood on the bed, and I saw blood below the bed. So what you are saying is absolutely ill-informed that it was all washed up.
Did you appear as a
that
witness?
house at 9 o'clock in that morning.
Did you appear as a witness?
Did you appear as a
Please answer that.
I did not appear as a witness.
Was it collected? Was it collected?
Then why are you talking?
Was it collected by Nada?
Yeah, let him say. He will tell you what the prosecution witnesses have said.
Why did you not make a statement to the police?
Can I make a statement?
Yes, go on.
Can I make a statement here? You see, Rahul, I'm a lead trial lawyer. I have cross-examined almost all the prosecution witnesses. One of the most important witnesses was the city SP Mahesh Kumar Mishra.
Yeah.
When he came at around 6:45 in the morning, his testimony in the court is that in Aarushi's room there was blood only on the bed, only on the bed sheet and on her pillow cover and on the wall behind it. There was no blood on the floor except the blood had seeped down through the mattress on the floor. Now therefore, the most important linchpin circumstance in the double murder trial was whether presence of Hemraj in Aarushi's room is established beyond reasonable doubt.
Yes.
On that aspect, the CBI had developed this theory of Hemraj being in Aarushi's room by the report prepared by Dr. M.S. Dahiya, who was given a piece of information that Hemraj's blood has been found on Aarushi's pillow.
And the wall.
Yeah,
he looked at the photographs.
And the wall as well, for which he relied only upon a photograph like a magician. But you see, the irony of the matter is, in the final report and in the 39 witness testimonies, what came out was that no blood, no sputum, no sperm, no biological fluid, no body hair, pubic hair, or any skin part of Hemraj was found from Aarushi.
That's an important point that you're making, and I want to bring in Aryaman Sundaram because this is an important point that the defense counsel is making. Quickly,
only 1 point.
Yes, one by one, please. Quickly.
To that extent, the basic linchpin and centrifugal thrust of the prosecution case was completely demolished. But today what we see in the judgment is that the learned trial judge has erroneously believed this.
Okay, Aryaman Sundaram, the judge says that the motive is established that Hemraj and Aarushi were in a compromising position, but there is no evidence to show that Hemraj was in that room.
On what
now
evidence?
You've got a forensic expert who looks at a photograph and he looks at a photograph and says that two spatters of blood, one belonging to Aarushi, the other belonging to Hemraj. Genius, who's a forensic expert, can look at a photograph and say that there are two spatters of blood. Aryaman Sundaram goes first.
I think you answered the question yourself by saying genius. He must be very much a genius to say that. But this is exactly what has concerned me about this entire case, and I'll make it very clear. What has concerned me is that in the rare cases where on circumstantial evidence you convict, the Supreme Court has been very clear that it should be beyond any doubt. The circumstances through an unbroken chain should not leave any doubt at all that such a crime has been committed. Equally, that the circumstances should be such that no second hypothesis is possible. Now, this does seem to be the guiding principle.
No, but Mr. Tulsi must respond to the point that Aryaman Sundaram and Tanveer are both making.
And I am finding...
Okay.
How do you establish on the basis of pictures that there are two streams of blood on a photograph on the wall? And how is it that you can't find a single sample of Hemraj's blood in Aarushi's room, yet you say they were found in a compromising position and this is proven beyond doubt? Mr. Tulsi, please explain.
Can I?
Yes.
Now the point is that if you have been found guilty of destruction of evidence, then that itself is evidence of guilt. A person, if the judge feels that yes, they are responsible for dressing up the scene of crime, that's evidence of guilt. Apart from the theory of last seen together and no other intruder coming into the house. Now the second point I want to make is that the advocate said that there is no evidence. The evidence is in a criminal trial, particularly of a murder case, the most unalterable circumstance is the seat of injury. In this case, the seat of injury is the back of Hemraj's head, and the seat of injury, the fatal injury on Aarushi, is on her forehead. The seat of injury, seat of fatal injury in the two dead bodies that are found speaks the story.
But you're not answering my question, Mr. KTS Tulsi, and my question is this, that if he was hit at the back of her head with a golf club and then with a scalpel, would there not be some blood of Hemraj somewhere in Aarushi's room? How is it that you don't find in any of the scientific tests that have been done, that how do you selectively dress up Aarushi's blood? How do you remove Hemraj's blood but leave Aarushi's blood there?
Nobody selectively dresses up. If there is a dressing up, you clean up 90%.
Mr. Tulsi, even after the dressing up, Mr. Tulsi, let me ask you one by one. Mr. Tulsi, even after the dressing up, there's a lot of blood of Aarushi which was lying in that room. If Aarushi's blood is lying there, how do you selectively dress up Hemraj's blood? Why don't you answer that question?
Because the dead body continues to bleed. The dead body is here, the other dead body has been taken on the terrace.
No, but there would be some blood which would lie in that room. Just imagine you're dragging a full body. There would be some blood lying somewhere in Aarushi's room. Aarushi Sundaram wants to come in and respond to what Mr. Tulsi is arguing. Mr. Sundaram.
It has been washed clean.
No, I think Mr. Tulsi is a lawyer I have the greatest regard for, which is why I wanted him to explain exactly this, which I think he has tried to do right now, which was, I was a bit puzzled by the fact that if there was dressing up, how were you able to determine whose exact blood belonged to whom when you were doing the dressing up? So that there is not even a trace of the other person's blood. No, I wanted an explanation on that. And I know you are not going to say because the photograph showed it.
No, but Mr. Tulsi, you must give us, as someone who believes in the case against the Talwars, you must be able to answer this. Even if there is dressing up, how do you remove every trace of blood of Hemraj, but you leave Aarushi's blood there? How do you distinguish when there's blood in front of you, which is Hemraj's blood, which is Aarushi's blood? Mr. Tulsi, please answer this question.
Yeah, can I answer? Let us suppose, for the sake of argument, that there are 100 spots. You have cleaned up 99, one remains, two remains, or 10 remain, and the dead body is there, dead body continues to bleed. And therefore there is much more blood which has fallen after the dressing up also, because in the meantime you have taken the other body upstairs. Now, you know, the question really is, under section 106, in case of last seen together, where there is no evidence of intrusion by an outsider, it is for the accused to explain the circumstances, because the circumstances are in their exclusive knowledge. They are the ones who have to explain the incongruities.
Vandana Talwar wants, you haven't answered the question.
Defense never
Even
realized
if there is blood in that mattress, the blood would be that of both Aarushi and Hemraj. If they were in a compromising position, think about it. If they're making out in the bed, both Hemraj and Aarushi are together on that bed, how do you remove Hemraj's blood, leave Aarushi's blood there? Vandana Talwar wants to come in. I'm also running out of time. Quick final comments. Vandana Talwar, please.
He's not. Rahul, you can't wipe out a mattress, and the nature of injury which has been said by Mr. Tulsi is anyway contradictory.
Absolutely.
He's saying some big injury on the back of Hemraj and on the forehead of Aarushi is going to lead to massive blood loss. So the mattress, how can you wash off the blood from the mattress? It's not possible. Plus you must understand that Mr. Dahiya has already said in his statement that the kind of injury which was there on Aarushi led to a minimal scuffle. So there was a minimal scuffle according to the forensic expert. So that is why the sheet and all were not disturbed. But as Masooma said, there was adequate blood on the bed sheet, on the pillow cover, on the wall, which we have all seen.
Okay.
Another point which I would like to make is,
Ms. Aarushi Sundaram spoke about there has to be beyond doubt, you have to prove the innocence, the culpability, guilt of this. I wanted to raise this, but we are running short of time. There was one very important piece of evidence which came up.
I want to make.
Nalini Singh went on national television 2 weeks before the trial closed, and she spoke about corroborating evidence of 7 people being in that room. That piece of evidence was put in an affidavit. The Talwar said, please call Nalini and Inspector Anuj Arya. Now, if you wanted to find the truth, and as CBI, you should have tried to go for the truth. You did not allow this. Neither the court allowed this affidavit.
Okay,
so
you heard from
this was premeditated.
You heard from Joginder Singh and KTS Tulsi presenting the arguments against the Talwars. You've heard Aryaman Sundaram, the defense counsel, and the family members arguing on behalf of the Talwars. These are questions that need to be answered, as Aryaman Sundaram says, beyond reasonable doubt in
Absolutely.
court. Have they been established beyond reasonable doubt? I
Not
don't
at all.
wish to take sides one way or the other. We've put the facts and the questions out in the public domain. Do you wish to believe Aryaman Sundaram? Do you wish to believe KTS Tulsi? You decide where you stand. Thank you very much to all my guests for joining us on Center Stage tonight.